Okay, so this is one of my favorite books. This is Constitutional Law as Fiction, Narrative in the Rhetoric of Authority by L.H. LaRue. He talks about the Constitution in this book and how most law students and professors in law are not required to read the Constitution, and they don't. And he says most people don't. He has a reference in here to James Boyd White, title When Words Lose Their Meaning, Constitutions and Reconstitutions of Language, Character, and Community. Marshall's opinions seem to be less an interpretation of the Constitution than an amendment to it, continuous with the original text. It seems continuous with the original text. I like James Boyd White. I have a few of his books on my shelf. I think I've read one or two of them, and he's also a co-author on some books that I've read, and I really like James Boyd White. He's a good author. I think if you're looking to read this kind of stuff, you should read some James Boyd White, as well as this book by LaRue, Constitutional Law as Fiction. So he talks about Marshall's court in here, and how Marshall was basically the first justice or judge that reinterpreted the Constitution. Now, I've talked about how in the first judicial act or statute for the justices, it doesn't say anything about interpreting or theories or anything like that, that as far as what the justices are supposed to do. It specifically uses the word administer. And I think the Constitution says administer the laws, this Constitution and the laws of the United States. So a lot of times we see that they are interpreting and theorizing about what the founders meant to expand the Constitution. And so what they're saying, LaRue as well as James Boyd White have said, is that when they do that, they alter what the Constitution says, they add to it, and this expands the size of government. So he talks a little bit about that in here. Now, the point I want to make, if you don't want to listen to me read, some people, I don't particularly care for listening to people read, but some people like it. So there's two things in here that he says besides the reference to James Boyd White, his footnote there. He says two things. Law students and their professors, in fact, don't really study the Constitution. They study John Marshall's opinions. The second thing he says is John Marshall had the genius to give us that something more. Now, that was stated beforehand, which I'll read in a minute. He showed us how to combine story and theory and thus recreate the Constitution. And as a result, lawyers read Marshall, not the original. When he says original, so he means Constitution. Okay, so now I'm going to read a couple of paragraphs here because I really like what he says about Marshall's opinions and the Constitution. So this is starting on page 84. I'm going to read 84, so the bottom part of 84, 85, and then some of 86. This great sentence, with its appeal to us to remember, belongs to a storyteller. To value memory is to honor the past. But Marshall also speaks as a theorist, since what he wants us to remember is a proposition. He wants us to remember that It is a constitution we are expounding. The theoretical generality of Marshall's claim is emphasized by his use of the indefinite article. He had used the indefinite article once before in this very paragraph, but he asserted that a constitution, were it to contain all of the details, would be too prolix. And now, here at the end of the paragraph, he repeats the phrase, and this time puts it in italics. Marshall may adhere to the Platonic thesis that one cannot properly construe the Constitution, the historically specific document, except in light of a constitution, an ideal type, or perhaps his thesis is more modest. He may be restating his thesis as a constitution is not a statute. I disagree. The earlier parts, because statute with statute, confederation with a federation, constatute. And it's a contract, a statute by contract. So, continuing now. The earlier parts of the paragraph authorize either interpretation. He has tried to elucidate the task of reading the Constitution by contrasting a constitution with a statute. He has also emphasized the nature of a constitution. Indeed, perhaps we must apply all of those distinctions to Marshall's oracular utterance if we are to understand it. So remember, we learned about utterances, sentences, and statements in Austin's book, How to Do Things with Words. If I am right that Marshall's prose sweeps forward so powerfully because of the skill which he weaves together narrative and theory, then perhaps it is also true that his prose would not persuade if he had relied on only one mode of discourse. Discourse is rambling, right? Talking, rambling. I have already noted how his narrative is vulnerable to attack. Marshall's story about the drafting process is reductively simplistic. He supposes a clarity of purpose where vagueness is more probable. He postulates a unity of purpose where conflict was surely present. Marshall's theory is equally vulnerable. The assertion that a lengthy and detailed document would fail politically, that a prolix constitution would miscarry, is also dubious. After all, our brief but comprehensive Constitution, its great outlines notwithstanding, is generally unread. Be honest. Who among you have ever read the document in question straight through to the end? And even if you have, do you know anyone else who has? On the other hand, consider such documents as the Torah, the Gospels, or the Quran. I list them in chronological order. These documents are the constitutions of certain religious communities, and they are far more complex and much, much longer than our political constitution. One might ponder the irony that very few law professors, who generally imagine themselves to be sophisticated intellectuals, have sat down with the Constitution and seriously contemplated its mysteries, whereas quite ordinary members of religious communities are serious about reading their text. Leviticus is far more daunting than the United States Constitution, and yet more of our fellow citizens have read it. Law students and their professors, in fact, don't really study the Constitution. They study John Marshall's opinions. This discrepancy, religious communicants have read their constitutions, but the legal community has not read its, can be explained if we acknowledge that stories are necessary. The Torah, the Gospels, and the Quran are rich in aphorisms, injunctions, narrative, philosophy, and parables. And each type of discourse, such as the aphorism, is made more powerful by being juxtaposed to other ways of speaking. By this standard, the United States Constitution is impoverished. And so, it is no surprise that something more is needed to make it come alive. John Marshall had the genius to give us that something more. He showed us to combine story and theory and thus recreate the Constitution. As a result, lawyers read Marshall, not the original. His voice is so powerful that it has replaced the voice of the original. If we grant Marshall's proposition that the details are to be deduced from the great outlines, how should the deducing be done? The second of the two paragraphs that I have quoted shows us how Marshall does it. Marshall's performance is splendid. And its splendor comes from its mastery of different modes of discourse. He doesn't voice the single line of a melody. His voice generates the multiple lines of a chorus. Marshall begins with the abstract description of the great outlines of the powers granted to the national government, and the vocabulary of this abstract description is largely derived from the language of the Constitution itself. Okay? So that's all I want to read for you today out of this book. And like, share, subscribe, and see you soon.